Hi, so good evening everyone. Today we will be doing one more important chapter, which is your Fugitive Economic Offenders Act. It's a completely new act. Okay, you will not find much content of this on the net as well. Okay, and this is the first time they have introduced for the CS portion. So today I will be starting and completing this entire easy little topic. So before I start, you have to open your modules. It's for the new syllabus. Keep your modules open. We will be completing the chapter today only. Okay, so request you all to keep your modules ready and also put in the chat box if you are good to go. If you can quickly start and complete the chapter. I'm waiting from for your message whether I'm audible, visible, and we are good to go. Yes, I just need you all to put in the chat box. That's all. Okay, so we'll quickly start with this chapter and complete it as well. Okay, Hariharan, you've asked one question whether the IPR chapters which you've taken, I'll release it one day before the exam. Yes, don't worry, for every single exam, CS exams, before the exams we are completely there. We make our lectures available. We also take marathons, revisions, everything. So the announcement will come. All you all need to do is be there in your chat, in the WhatsApp and the Telegram groups. You will get all the updates with respect to that. Okay, so don't worry. So I'll quickly start with this topic. Okay, just give me 2 minutes. I'll just get my charger for the laptop and then begin. Okay, 2 minutes and we start. Okay, so let's start. Just one last time, if you're going to put in the chat box if I'm visible, audible, and we are good to go. Okay, great. So if you all can just reconfirm, I need you all to open your modules. We will be completing the entire chapter from the module. Now before I start, just a small confirmation whether I'm audible and visible, and we will start with this chapter. Not only start in one flow, we will complete the entire topic in great detail. So just give me a in the chat box that I'm audible and visible. Great. Thank you so much, Hariharan, Sona, and Yeshu. Let's begin. Hi. So we will be starting one very important chapter, which is a law relating to fugitive economic offenders. Now, when you look at this actual act was a new act. It was passed in 2018. And it was in the backdrop of various economic scams that India faced, specifically the Indian banking sector. So when you look at here, you know that it is Vijay Mallya, Nirav Modi, Lalit Modi, and Mehul Choksi. Now what exactly happened? Let me tell you. So all these persons, Vijay Mallya, a 9,000 crore scam. Your Nirav Modi, 11,000 crore scam. Then we have Lalit Modi, 2,000 crore scam. So when you see, all these scams are not in lakhs, these are in thousands of crores. And when I say these are in thousands of crores, who do you think must have faced this loss? It's obviously the banks must have faced these loss, and the banking sector faces a massive amount of hit due to these kind of financial frauds on them. If you go to see, even the banks, it's not their money. It is the money of the people of India. You and me, who have deposited our money, and now this money has been given as loan to these people and they are not going to come and return. So this caused a huge loss, and it's very, very important to catch these persons who have, who have now not available. Now they know these offenders, they know that they will not be able to repay the scams or have done money laundering, or there is a warrant issued in their name. So what do? They run outside India, specifically in territories which protect these people because of the corruption and the financial gains that they will get by helping these persons. So they generally run to the UK. So if you see, most of them are out of India in UK or in some other countries which will protect them. So, and the funny part is India never had any law to prevent this, or if to face this also, because of which there were huge amount of time delays. Until now, none of these offenders have come. And I'm talking of 2023, 2024. They are not in India only, or have been brought in India. So the introduction, it starts in the chapter. They say that there have been several instances of economic offenders fleeing the country, okay, because they feel that they are anticipating arrest, anticipating criminal proceedings. Now since they are not there, even trial cannot be done or started also, and it is ultimately wasting the time of the court. Now obviously these are financial scams, so it worsens the financial health of the economy and the banking sector. The problem lies when the existing laws, the current laws before the Fugitive Offenders Act 2018 was passed, there was no law to tackle this, to counter this. And then the government of India passed the Fugitive Economic Offenders Bill 2018. What is the object of the act? See, any law that you read or any law that is passed, it is passed after a proper objective. No law is just passed. There is a certain purpose for the law. Here, the purpose of the Fugitive Economic Offenders Act 2018 is first to deter, to stop, discourage the fugitive economic offenders from evading the process of law and running into a country outside India. So we want to stop economic offenders from running out of India, and obviously once that is done, like when the law was not there, people did not have belief in the system of rule of law in India. They said, what happens? You are giving big loans, who are taking big loans are running out of India. What is the use? So it is affecting the rule of law in India, the trust in India, the sanctity in India, the purity of the Indian law is being challenged, where people are not having faith in the Indian judiciary because of the slow process when it came to economic offenders. So to ensure that this does not happen, the Fugitive Economic Offenders Act has been passed, and now you will see there have been very strong, strict rules to tackle with such cases. Now let's see, when I'm saying fugitive offenders, now we are seeing under the Act, what all provisions have been given under the Act. First, before understanding what all measures have been done to deal with these fugitive offenders, let's understand the meaning of the term fugitive offender. So section 2F of the Act, Fugitive Offenders Act 2018, defines what is a fugitive offender. According to you, who is a fugitive offender? Someone, see, now the name is fugitive economic offender, means it must be an individual, and since he is an offender, a warrant also must have been issued, against whom a warrant for arrest has been issued in respect to a scheduled offences, okay, by any court in India. So 2-3 points are there. First is, who is a very, very important definition. It's the entire Act is based on this. Fugitive economic offender means an individual against whom an arrest warrant has been issued. So when you see all these scamsters must have happened, the arrest warrant must have been issued, and in order that the arrest could not be done, they go out of India. And so they, in order to avoid the criminal prosecution, they have left India and have been abroad and refused to return to India. Now, the offense also that they have done, a list of offenses have been given, like money laundering offenses have been done, your Negotiable Instruments Act, that is your checks have been bounced, check bounce case, loans have not been repaid, certain, all those terrorism. So all those offenses have been given, that if these offenses have been done, obviously the person knows that he will be arrested, so he ran out of India. So he left India to avoid the criminal prosecution, and being abroad refused to return India. Now the entire Economic Offenders Act. Now you tell me, if I have done, if someone has done a scam of 70 crores and has run out of India and he has gone away out of India, will this law and act be applicable? Yes or no? So 70 crores scam has been done and he's gone out of India and he's refusing to come into India. He's done some of the scheduled offenses. So the answer is act will not be applicable. What? Act will not be applicable because 70 crores is baby money, very small money. We are talking of 11,000 crores, 15,000 crores, 9,000, 70 crores is nothing, peanuts. So here the threshold for the invoking this act, for this act to be applicable, is 100 crores or more. For less than 100 crores, this act is not applicable. Okay. So here they have told you, when I told scheduled offenses means what? Scheduled offenses means if the total value of the scam of the offense is 100 crores or upwards, then only the Economic Offenders Act is applicable. First important things. Next. So what all are given in the scheduled offenses? So if you see any act under IPC, almost every criminal law has been covered. Check bounce case, 138 of Negotiable Instrument Act, RBI matters, excise, customs, under the Benami Properties Act, if you know, we've also done Benami property, if there is a prohibition under those. Then comes Prevention of Corruption Act, SEBI Act, LLP Act, FCRA Act, okay, offenses under the Companies Act. So they have given you a list of offenses. Black Money Disclosure Act, Section 69 of the IBC Code, of the GST Act. So these are all different acts that they have given you. If you one has done a scam, violation of 100 crores or more of any of these acts, the Fugitive Offenders law will be applicable. Now my question to you, if you are the lawmaker, what will you possibly do to someone who's gone out of India, who's taken the money and run away, who is not repaying the loan, who is not coming back into India? What is possibly to be done? What does a law contain? What are the main provisions? What do you think they will do? What do you think they will do? So very first thing is, Government of India, in order to deal with these cases, has very first made a special law, a special court to deal with this. So they will make some fast track court to deal with these matters, because if someone has taken a huge amount of money and has gone outside India, and it goes in the regular high court or the regular courts which are there, it will take years to get an order, then to go abroad. That is what happened in all these offenders. That was exactly what happened in all the previous cases. So law has made a fast track court. A special court has been designated. Once it has been designated, then what will happen? Then immediate basis, a director is there. Director of money laundering could be there. Director of those special officers who are there. They will issue a notice to the accused, that is the offender, and they will tell him to appear. You come before the court, come before the special court. Obviously he will not come, or he will come with his counsel. If he comes with his counsel, the proceedings will start. But if he doesn't come, he will be declared as a fugitive economic offender. We will declare him as an offender. Then what? We've declared the previous ones also as offenders. What happens? Now see, they are economic offenders. They have taken money and they've gone. So the best thing that we can do is seize all their properties. So all their properties, so the director who is there of money laundering or any other like officer will immediately prepare a list of all his assets that he has, whether he has properties, cars, bank balance, everything will be made a list and it will be confiscated. Moment it is confiscated, they become property of the central government. Okay. Now, once that is done and you declare, you seize all his assets in India and outside India also, because even the government, once the order has been passed, since it's a fast track court, order can be given in any convention country, that is a abroad country, that listen, order has been passed and please do the needful. Extradition provisions is given under separately to be done. Here we are talking of the money to get it. Okay. And we are getting the initial court case to be given early so that we can arrest and get him. So it starts from section number 4, the main provisions. We will declare person as offender, confiscate his property. Section number 4. Application for declaration of fugitive offenders and the procedures thereof. Where the director has reasons to believe, the director could be director of money laundering or any other level high rank officer has reasons to believe that any individual is a fugitive economic offender. If they feel that any person is a fugitive economic offender, what will he do? Can he go and shoot? Answer is no. He will go and file a case, because only court can declare a person and later, after the proper judicial proceedings, due process of law, then only you can put them in jail. So the director will file an application in special court to declare such person as a fugitive economic offender. So let's see the procedure. Okay, what is to be done? Very, very simple. It starts with the director. Director could be the director of money laundering or any other officer not below the rank of a deputy director. Director who has reasons to believe that on basis of whatever evidence he has, materials he has, that any individual is an economic offender, he will file an application in the special court. Now when you file an application, the director will file an application in special court, then he will have to give all the facts. Facts will have to be given. What all facts will you give? Reasons why you feel is an economic offender. What all information do you have about him available, about the whereabouts? You will tell that, listen, he's gone in this country. List. We are mainly concerned of economic aspects here. So list of all the properties that we believe in the proceeds of crime. Okay, if there are any benami properties mean obviously these criminals, when they are there, they don't hold properties just in their name. They might have some money must have been given to someone to buy the property. So even they are the beneficial owner, but maybe the on the books registered owner might be someone. So even the list of those benamis properties which we can go and seize. A list of persons who may have interest in any of those properties. Now it is possibly some of those properties might be joint owners. So who all are there, we have to give the complete details. Now when we say proceeds of crime, very, very simple, just the general meaning. That means any property, money derived from criminal activity is proceeds of crime. Okay, and the crime is with respect to scheduled offences. So scheduled offences, when you've done of a value of 100 crore or upwards, then this act will be invoked. Now, till now what we saw, director making an application to court. Then court will issue the notice to this person. Okay, and any other person who we feel has interest, as I told you, co-owners, his wife, his family, etc. A notice. In the notice, what will the court tell? The court will tell him that please come to court. Come to court. Okay. And that too in not less than 6 weeks. So we give them 6 weeks time to appear in court. Very, very simple. We are being fair. We are giving him notice that please appear in court. Now, if he doesn't appear, then we will declare him to be fugitive offender. One, very simple. and we will confiscate his property. So this provision, okay, is extremely hard on the offender, that if I don't go, my properties will be confiscated directly, because no one to hear to represent me only. Whatever director will be saying will be one-sided. So it's risky. But obviously if he comes, he might get arrested, so he will not come also. Possible. Not only that, before, these offenders are one step ahead of the courts and judicial systems. They know that they will get confiscated in India. So what do? Through Hawala or through other unauthorized channels, they transfer their entire money abroad. Through shell companies, they must have transferred the property, the money abroad, and in India, very little thing must be there. Tip of iceberg must be in India, the entire iceberg is out of India. Full money is outside India. So then we will also have to issue a notice. The court will also issue a notice to the contracting state. Contracting state is with country with which India has a treaty. For example, Indo-Mauritius treaty. So we have good connections. There is any other treaty which we all have signed together. So we know that we are going to help each other. So we will immediately tell them that, listen, this person is there, he has these properties, please seize it. Next. Now, this we gave the notice. At the same time, the notice may also be served by electronic means. Now it's a digital age, you will share it. You know, your Aadhaar card has been linked to your PAN card, has been linked to your bank account. Now we will use that in this act. From the Aadhaar card and the PAN card, we will get the address. We will issue a notice there also. Once we do that, okay, the person shall appear in person, where a person appears. So we will terminate the proceedings. Very simple. He comes before court and he says, listen, what nonsense all this is going on. I have not run away anywhere out of India. I am here only. So then the court, after hearing, realizes that he is not a offender who has gone out of India. They will terminate the proceeding. But this is very rare. He coming is also very rare. He not coming is also possible. But what is the biggest possibility that has happened in all the economic offenders cases is they appear through counsels. They appear through a lawyer. In such case, we will hear this application and then proceed with the hearings. Now, where any individual fails to appear and the special court is satisfied that the notice has been given or he is evading the notice, then it will continue to hear the application. So if the government feels that, or the court feels that, listen, notice we have given him, or notice we are giving him but he is not taking, so we will say we don't care, we will now start listening to the application. We will start the hearing and listen and hear it one-sided. That's it. Now we are hearing the case, let's say, and this person is found guilty. After hearing, we saw all this hearing, notice and all this, electronic means, Aadhaar card, PAN card, all we will do to start the hearings. Once the hearing is done, then under section 12, when he is found guilty, we will declare him to be a fugitive economic offender. We will declare him to be a fugitive economic offender. So here they start that if a special court is satisfied that an individual is an economic offender, he may by order declare the individual as an economic offender. Okay. So the first one is declaration. But after declaration is fine, but we want the money, right? We are mainly, he's taken the money, so how do we get the money back is the second point. So now we are talking of attach the properties. On declaration, the special court will order the properties that it stands confiscated to the central government. All the proceeds of crime in India and abroad will be property of central government. Any other property or benami property in India or outside India is property of central government directly. Okay. Then, and they should identify the properties, because now see, moment that person didn't come, we quickly do a fast track court and pass the judgment. Moment we do that, then we will now make a list of how much properties we have got and how much money is spending, etc. Next, the confiscation of the order shall be separately list any other property by this in India which is to be confiscated. So if there is any other property which is that also will be listed. Where they have made an order for confiscation in a contracting state. Contracting state is a member country of a country with which we have a good rapport, or we must have entered into some treaty contract. So we will tell them, listen, the special court will issue a letter of request to the court of the foreign country and tell them, listen, these properties are there, please sell it off and transfer the money to the central government account. Even every letter of request transmitted to the contracting this shall be under the name of central government, okay, and will be told and said how the central government will tell the form and manner of communicating to these foreign countries. The special court, while making the confiscation order, this is their just relief. They will exempt the confiscation from any property which we believe is not of the economic offender and has an interest in the property and has acquired it bona fide without the knowledge. Now, let's take this example. Let's say it's a joint property. It's a joint property of Mr. A and Mr. B. Mr. A is a fugitive offender and this guy was an innocent party. So if we realize that this guy has done all his white money is there, genuinely job he goes and he must have earned, and he got scammed by this Mr. A into buying this property, 50% this guy paid, 50% this guy paid. So we will say, listen, this guy's property cannot be confiscated and this property will be exempt from confiscation. Next, all the rights and title in the confiscated property will become that of the central government. Simple. Next, where now we are also taking if he wins the case. If he say that he is not a fugitive offender, they will release all his property. Where an order releasing the property has been made, the officer will still withhold the release of such property. Now see, 9 and 10 is about that he won the case. But in 10 is saying even if he wins the case, we will still withhold the release of the property for a period of 90 days, 3 months. Can you tell me why? Court has ordered that he is innocent, but still we are not releasing his property for 90 days because there might be a possibility of appeal. The government or the director will go in appeal that listen, this was a wrong judgment, he is an economic offender. If we release it, he might sell and go away. So 90 days time also has been given to both the parties to go and appeal. So we will see the appeal provisions also. So till the appeal is also disposed of or appeal is not made, then also we will say wait, don't release the property now, appeal is going on. Let the higher court decide what is happening. Section 14 talks about power to disallow civil claims. What do you think it must be? Power to disallow civil claims. Okay. Now very simple. Once the order is passed, can anyone be allowed to make any claims? Once the order has been passed, can any case be filed? Answer is no. So on declaration of an individual as an economic offender, any court in any civil proceedings may disallow such individual from putting any claim. Why? Because declaration is already given. We must have already had an hearing and now you are coming, so it is not allowed. And any court may disallow any company, LLP, from putting forward or defending any claim if the promoter or the main shareholder is a fugitive offender. Again, even a company, it will disallow, not only they are disallowing company also. Why? If the person filing the company on behalf of the company is having a controlling interest in the LLP or this, has a been declared as a fugitive offender. Let's take an example. We have Vijay Mallya. Okay. Now Vijay Mallya, he goes after being declared as a fugitive offender, tries to make a civil case, makes a civil claim. So will he be allowed? Answer is no. Second, Vijay Mallya is not coming, but Kingfisher Airlines is coming and making a civil case, civil claim. So even they will be disallowed. Why? Because Kingfisher Airlines is controlling powers is of Vijay Mallya, and Vijay Mallya has been declared as a economic offender. So both are disallowed. Next, if we see the KMP, obviously KMP definition is same as that and given in company law, and LLP is same as that is given in LLP Act. Attachment of property. Director may, with the special permission of the court, attach any property by an order in writing. Now the thing is, let's say for example, with the permission of the special court. If now they're giving you a case, now obviously with the permission of court only they can attach. Now they're giving a special scenario. The director can also attach any property for reasons that he believes is a proceeds of crime owned by an individual who is a fugitive economic offender, and such person is being or is dealt with in a way which may result in the property being unavailable for confiscation. If we feel that, listen, if this particular property is not attached, he will knock it off and we will not get the money. So in that case, if we feel, the director feels that this property will not be available for confiscation if not attached today, so then he can do that. However, whenever the director attaches, it can only be for 180 days. Okay, 180 days. Let's see. The director may provisionally attach it. This is a provisional attachment because final verdict will be given by court. Shall within a period of 30 days file a application before the court from the date of attachment. So again, if the director feels that this guy will run away with the property or try to sell it off, they will attach it. Then in the next 30 days from the date of attachment, he will file a case before the special court that, listen, I have attached the property, you start the proceedings. The provisional attachment shall stay for 180 days. This is very common. Even in money laundering, provisional attachment for 180 days. Power of survey. Very, very simple. Now, what is happening is, if we are talking of property, movable property, important documents, etc., if you want to know that how is the entire transaction done. So in that case, we require a director to have the powers to enter into any place, inspect any place, survey any area, examine anyone, take recordings, confiscate, search. All of those powers are there. Break open any particular door, everything will be there. So where the director has the reasons to believe that that an individual may be an economic offender, then he may enter the place within the limits assigned to him, or in respect when he is authorized for the purpose of this section, who is assigned the area within such place is situated. So again, he can go wherever he's been designated, like in the search warrant is issued, they tell the demarcation where search can be done. Where the director has reasons to believe that any individual may be an economic offender, it is necessary to enter in any place. He may request any proprietor or employee to afford him necessary facility to inspect such records. For example, let's say there is an economic offender and we have to go to the company, okay, and go and enter into the company, his cabin, his closet, his cupboard. So we can do that, open up his file. So then the director will tell his employees that, listen, or the owner who is there at that time, so that they can inspect such records, check and verify the proceeds of crime, and any other matter, furnish any information as they may require. So they can enter. The director may. Now whenever the director enters, now we just understand a case where they are entering inside, they are taking permission, they are going and then doing inspecting. So whenever they inspect, they put their own marks that they have checked it up. They'll make an inventory of all the property checked and verified by them, and record statements of all the employees or any of the employees as witnesses. Then search and seize. Obviously this is very simple provision that they're talking about, where the director has reasons to believe that any person is declared as an economic offender or has proceeds of any crime or proceeds of any recordings or records or proceeds of any property, then he will tell the officer, enter the building, break the lock if necessary, seize any property if needed, put the marks. So whenever they seize, we should know now what all they have seized, we should know what all marks they have put, so that in court we can present, take a note of the inventory that they have was present, how much was confiscated, how much was examined. They would also call in some of the employees, key employees, and see where the authority upon information obtained during survey is satisfied that any evidence shall be likely to be concealed or tampered, he may for reasons enter and search the building where such evidence is located. So normally if there is, let's say, some registers where it was written about all his transactions, and we know that someone will go and try to dismantle or will try to tear it up, so they can also enter and search the building where the evidence is there. Not only the things, but they can also search any person. If any authority has any reasons to believe that some person has secreted about his person or anything in his possession, he may be, and which may be useful for element of the proceedings, he may search the person and seize such a record or property. For example, if I had the key, or I had a USB drive, or I had some hard disk, it can be taken, or I had some papers, document papers, so all of that can be taken. The moment you take custody of a person, then you will bring him within 24 hours to the nearest police or the magistrate also. Where an authority is about to search any person, he shall, if such person so requires, take such person within 24 hours to the officer or to the magistrate. Now this is there even in our constitution that they've given, that moment the arrest is done, within 24 hours they should be before the magistrate. But tell me one thing, if the travel time to take to the court is taking, let's say, 2 hours, so should that be counted in 24 hours? Answer is no. The transit time is to be excluded. Very, very important, that transit time is excluded. You can write it down. It may be noted that the period of 24 hours shall exclude the necessary time for the journey taken to take such person to the nearest magistrate court. If requisition is made, the court shall not detain a person for more than 24 hours. If the gazetted officer or the magistrate sees no reasonable grounds for search, they will forfeit such or discharge such person. So if the person is saying that take me to the magistrate within 24 hours we should take, and when the magistrate says listen, we don't need to search him, he will be discharged forthwith. Now again, very important, whenever search is being done, okay, they normally take 2 witnesses with them. 2 or more witnesses shall attend and shall be seeing the entire search or the raid being done. The authority shall prepare a list of the records seized. No female shall be searched by anyone except a female. The authority shall record the statement of the person searched. So who all they've searched, that also we have to note it down. Now comes section number 16, mark it as important, the burden of proof. Normally, if the director of money laundering is saying that you are a fraud, burden will be on director or on the person. If I am saying that you are a fraud, we will presume innocence or we will presume presume the crime? Correct. Very simple. That a person is deemed to be innocent till he is proved guilty. So here the burden of proof that a person is an economic offender and the property is proceeds of crime shall be on the director. But if someone is coming and saying, listen, I am a genuine guy, I have done absolutely nothing, everything is this, so we'll say, listen, to prove that you are bona fide, the burden to prove that you are bona fide and you have wanted to genuine means get your income taxation statements, the burden of proving bona fide acquisition of property is on the person. See, means what? Director has to prove crime. And if you want to prove that you have got the property through bona fide means, then show it. Notwithstanding that, where any person or someone is saying, where any person claims that any interest in the property was acquired through bona fide means, and I don't know anything about any crime, without knowledge of fact that such property constitutes proceeds of crime, so the burden of proving such a fact shall lie on him. The standard of proof applicable to determine the facts shall be preponderance of probabilities. Now, what is preponderance of probabilities? Standard, this is a very common thing. Preponderance means we will who is the probability is what? That the benefit on prima facie looks in whose favor. So the judge or the court will see here both the parties and they will see that the balance of preponderance, insaf ka taraju they call it, is in whose favor. If it is in your favor, the probabilities you will be benefited. But if the benefit is not in your favor, then it will go against you. So the rules of evidence will apply. That is given in section number 16. Appeal. Extremely simple. First, the director makes an application to the special court. From special court, you can go to High Court within 30 days from the date of the judgment. High Court can entertain the appeal after a period of 30 days if it is satisfied that a sufficient cause is there for not preferring their appeal within 30 days, and no appeal shall be entertained after a period of 90 days. That is why, remember, we had done earlier that 90 days we can keep it on hold because someone gets a time to go in appeal. Normal time period is within 30 days from the judgment received, but sometimes due to sufficient cause they can give you extension of time, but in no case will you get time more than 90 days. No appeal shall be entertained after a period of 90 days. So normal time period is 30 days, but extension can be given to max 90 days. Bar on jurisdiction, very, very simple. That bar means a stop. No other court in India can take up the matter once it is there, a special court is made. And the overriding effect, the Fugitive Offenders Act has overriding effect in any law in India. That means if there is any provision in any other law, we will say you don't have to worry. Though if there is a conflict between the Fugitive Offenders Act and any other act, the Fugitive Offenders Act will apply. This is called as overriding effect or superior effect. And bar on jurisdiction, again very simple, because see, logically this is a special act, special over general. So special act, special procedures, so the general rules will not apply. So no civil court shall entertain any suit with respect to this which a special court has been empowered to deal, and no court can even grant injunction or any other relief except the special courts. And that is it. We've completed the entire topic and chapter on Fugitive Economic Offenders Act. Thank you. Okay. So that is it. The entire chapter is over. One entire chapter knocked off for you. Okay, so seemed out, brother. Even I want to know if all the 20 lessons in tax law will be covered. If yes, then the tax law for law will start from when? Okay, now Sona has asked a very good question. Is first is for how much years he will be in jail. So if you go to see, this is the entire Economic Offenders Act. Okay, now they have not given you the years of imprisonment. That comes in different laws. Okay, that will be seen. Here we are just giving about the taking away the money. Okay, and it's a very small act. This is just about confiscation of his property and getting him into India, and then depending on all the other laws also will apply. But if there is a conflict, this act will apply. So don't worry, with respect to all the subjects there will be revision lectures. Right now I'm just taking in for this from other chapters revision also. I'll keep telling you all. So this is it. I've completed the entire chapter. You go and see. Your job is to complete this entire chapter from the module. Okay, that is it. I'm done with the chapter, and this is the first time we've taken or anyone has taken this particular thing in the new syllabus. Okay, so that is it. Okay, thank you so much guys. See you all tomorrow.